present, which would bring back that previous motion to dismiss. Then the last and final thing, and I did not include this in the written motion simply because
Turn it up some more, people, so I can.
I think this extends into the pattern I was talking
Because
about.
on record.
Even the simplest of evidentiary items seem to have been withheld.
Withheld.
The polygraph
I want my case
examination,
on.
as I stated at the last pretrial conference, we've been asking about that since January 22nd pretrial. I asked again at our pretrial on August the 18th. It is in archives apparently, and Mr. Chavan is making attempts to get it today, the day of trial.
That's 2 lawyers.
Our 4th trial date. I think I addressed in the motion somewhat suspects other than Mr. Porter. There seems to have been
Suspect.
one at some time.
Other suspect. Prior family conviction
I'm not
deal.
sure if there may be others,
Remember,
and that's something that we've
4th time.
consistently asked for that information. The deals with Mr. Pendergrass and Mr. Gully.
I got paid on.
At our last trial date on April the 7th of this
That's
year,
when
I was
what's
told
called his mean mother.
by Mr. McKay on the morning of trial orally that Mr. Pendergrass' cases were dismissed for his cooperation with the Commonwealth. I never received anything in writing to that effect.
What time is it?
This morning,
Just now.
that's changed. It's a dismissal, but it's for different reasons because the
Now
case
it's
was
changed.
weak because the prosecutor at the time thought Mr. Porter was saying that Marcus Pendergrass had nothing to do with it anyway.
Listen to that. Why
So
would I
the
say
reasoning
that?
has changed on the morning of trial. The next
They've been
item
changing facts.
being the deal with Mr.
They're
Gully.
tampering with public record. I ain't
there
never
seems to
said
be a
that.
deal,
Y'all would have to
but
have that in
he
writing.
is pending indictment in Division 2 for flagrant non-support. And at this point, I think I'd be interested to know what Mr. Gully's conception is of what he was receiving in return for his testimony, if anything.
3 or 4 days before he owed,
The next thing that
before
we've
trial,
asked for
he owed
consistently and not received are
$25,000.
the felony
The
convictions
day of
the
trial,
Commonwealth Attorney's
that
witnesses
$25,000
at the last
got
pretrial
dropped down to
conference
zero
on the
somehow.
18th of August. I reminded the court that the court had signed an order in January
They just overlooked a
to
lot.
turn over exculpatory evidence
It-
to
no, they
include
know
felony
the book.
convictions of the
You
Commonwealth
had people
Attorney's
pulling
witnesses.
strings
I have not
and
received
covering
that
up.
list yet. And I was informed this morning that the gunshot
Cover up and overlook these
is
two quite the different things.
It was just about.
Whether
Yeah,
was before
you
or
can't
after
find
the
shit
trial.
if it's covered up.
Apparently
Yeah.
never was, and that was
In the
information
movie, A Few Good
received
Men,
this
they said you
the
probably
reason
forgot
I
what
add
he
these
specialized in.
things at
They
the
can make
end
a whole airplane flight
was-
disappear.
I know the court's aware of them, but it does.
They killed
Create
Kennedy.
an
The
even
public
more
thinks they killed Martin Luther King. The
I
public think it was
when we
just
place
outside,
this
blah, blah,
morning's
blah.
items in the written motion in
Look how
context
powerful shit is.
of the previous
Trump got elected.
actions that have taken place.
So-
and that's
House of East.
the gist of my argument.
Judge, working backwards and with
Working
a
back.
clear understanding
Listen.
of this outrage, these
11 o'clock on the nose.
are absolutely scurrilous, slanderous, and bold. And I'm frankly outraged by them. And here's why. Number one, on the GSR, I'm going to work backwards.
Gunshot
It clearly
residue.
states in the discovery that there was no GSR taken because Mr. Camp had been fingerprinted. It's in the discovery. I don't have to explain that to them again once I've turned it over. I, as a courtesy, reminded Ms. Kingren of that this morning, based
They
on her
didn't
previous
do nothing
motion.
on me.
Number two, my note says here.
He's the campaign.
In terms of people who have prior felonies, I don't know of any. I am not aware of any. I do not have the records of any. I have disclosed what the deal was with Mr. Pendergrass. It has not changed. The case was dismissed, and as a condition of that dismissal, he was required to cooperate with the Commonwealth. That's exactly what I told her today. It was a more full explanation than I gave her originally, which simply said the case was dismissed. And I explained all of the circumstances, which included the fact that the case was weak against him, and it was my understanding that Mr. Porter was going to say that Mr. Pendergrass wasn't involved. I can't do anything beyond that. I've completely complied with my obligation and explained it twice to them now. In terms of,
Right here.
and that takes care of the dismissal, the polygraph evidence is in archives. I can't get to it. We are making attempts to get it. It's a polygraph, so the court's aware. It's a polygraph of the defendant.
So they said I free Marcus.
What
Y'all
it's
don't have it
going to
in
read,
writing.
I don't know.
Y'all fabricated
I
that.
don't see of any relevance that it could possibly have. It has no exculpatory value because the defendant's aware of whatever it is he told the polygraph examiner, and the results of that polygraph are not going to be admissible in this court. So to to try and twist that into some kind of attempt by the Commonwealth to hide that information is ridiculous. It's outrageous. In terms of the civil action, I don't have anything to do with that. I'm not aware of any civil action. I didn't partake in any civil action. I am prosecuting this man for committing a crime. The crime is murder, and that's all that concerns me. The fact, even if I were aware of it, how in the world is that exculpatory that someone has taken it on their own accord to file a civil action against somebody else? I'd love to see how that's going to come into play in this courtroom. And how that's
we'll show. I'll show you in a minute.
Which I've been here for 3 hours, Judge. I've been here since 9 o'clock, and I'm handed this 10 minutes ago. 8 minutes of which Ms. Kingren discussed it, and we read it. That's outrageous. In terms of Mr. Brown, I was never, ever, ever made aware of the statements that he made to Ms. Kingren and her investigator until this morning.
Never.
When I was made aware of them this morning.
This morning, not yesterday.
He already told Ms. Kingren.
Jim's on it.
Now, why in the
Jim
world
looked
is
at
it
all of
that I'm
this.
supposed to tell them what they already
Dissected
know?
all of this.
That is outrageous. That is spurious. That is specious.
Went to
The
Kenneth
fact
Brown.
that,
Kenneth Brown told me, man, I went there
and I
that
also
night.
contend based on
He
my
said he didn't
conversation
talk
with
to him till this
Mr.
morning.
Brown,
the
that
day
this
of
is what I
trial.
can say. It is this.
So he lied to the
That's
court
what he
right there.
indicated to me that he indicated to them, but he has not wavered in the sense that he is still going to identify this gentleman as being the individual he saw that morning.
So Jim didn't
And I'm
ask
not
him,
gonna
why
get
did you
into
testify? Because
the
AC told me
things that were
that
said to him. In an
he
attempt
said you got the
to,
right guy because we got
change
his
mind
brand
about
of
what he
cigarettes
saw.
that he smoked.
That too
He
was
left
outrageous.
clothes there, type of
Certain
thing.
items
We
and
know
evidence that have
clothes he
nothing to do with
left
this case
and
were
all this other
suggested to
stuff.
him in an attempt,
Bunch of
based on
junk
my
lies
conversation
that ain't
with
part
him,
of that
it's
he
clear
never
it was an
later on
attempt
introduced.
to inject doubt into his identification where none should
That's what he
exist.
did with those
The
3
example
things I
is
told you.
that there were cigarette butts at the scene of this crime. They are in no way connected to anybody associated with this crime.
So
But
it is
suggested
some.
to him that
Right.
Mr. Porter doesn't smoke. Therefore, he couldn't have possibly been this man. That's outrageous that was done to this witness. Nevertheless,
By you.
his identification will stand and will speak for itself. Nothing that I've done wrong, nothing that I was aware of, and if you want to bring Mr. Brown in here and ask him, I'd be happy to do that. The second part of this, under number 13, talks about Cecilia Camp not being indicted along with Juan Sanders in a different case. What we have to do with that, I do not know. How that impacts this case, I have no idea. It's characterized as special treatment, and that's wrong. There is no evidence of that. There's certainly nothing on my part, and I'd be the one to make that call, Judge.
I'll
as
be
to
the
whether
one
or
to
not
make
she
that
was
call.
To get some kind
So
of
you
special
do know
treatment in
about
terms of this. Never was there a conversation between myself and any prosecutor on that case. Never was there a discussion about whether or not she should be charged. Never was there any linkage between these two cases beyond the fact that they share the victim's wife as a witness in one and the wife of a victim or victim in the other one. Not my case. There were no deals made. There still are no deals made. There's nothing to turn over, and to suggest otherwise is without basis in fact.
Without basis in fact. I always remember
the next
that.
one is a life insurance policy.
Here's the one. Now listen to this carefully. This is what I thought I was going to stop you on.
If that's exculpatory evidence, it's something they were already aware of apparently, and there's
He's
no
going to say, I
prejudice.
don't know, and
How
turn
it
back and
impacts
say,
on
he
anyone
does.
else's motive to kill this victim, I guess is the theory, but it in no way is evidence that's going to come into this trial from the Commonwealth. It's not something I'm putting in. It's not something that in any way
Because it
exculpates
protects you.
Mr. Porter. It may be something that if you believed that Celia Camp was capable of doing such an outrageous thing, then
Look
you
how
can
you
supply the
feel.
motive. And if she were on trial, maybe it is something we would put in. I'm not aware of the terms of that life insurance policy. I'm not aware of who the beneficiaries are. I know that she was one of them, and I think his mother was the other.
I'm not aware. But then you
Maybe
say this.
Equally suggested his mother killed him. And maybe that's the kind of evidence we're going to hear.
That's crazy.
To call that purposeful withholding.
I'm not aware of
exculpatory
any
evidence,
kind of that.
boggles
And then he
my
says,
mind.
I know
And
with
it
this
comes from the
person.
terms that are so accusatory and so personal outrages me. And I ask the court to make a finding of fact that none of those things
Finding of
exist,
fact.
and that we move on and try this case.
That's Cynthia Cricket you just seen. I just beat her in a drug case and made her mercy rule. And now I got a dismissal right here.
Absolutely not true.
Like they
The
did in
first time
Barbara's
he
case.
spoke, it was this morning, and when he did, I
Keep
went
on
to
been
Detective
killing
Ken and
cases.
told him what he
Indictment
said,
number
and we had a discussion with Mr. Brown concerning that. And
97
I'd be happy to bring up to
2091.
Because it's
It's over here
simply the
somewhere.
fact that we have never ever discussed
2021.
his wavering,
See if I got it.
quote unquote,
You
on
can
this
say it.
identification. I never
20
had
no,
information he spoke to the
2091.
investigator or
2091.
until this morning, and that is absolutely the fact.
The
If I
opposite
could
of
briefly respond,
What do you
Judge.
just?
huh?
Let me see where I should begin. Okay.
Wind that back there, man.
Mhm.
I want to see the last thing he
The
just
first
said.
thing
Okay.
that I find troubling is that
Troubling. I thought she did.
Paragraph 8 of the written motion indicates that Mr. Brown came to you as early as April the
Yeah.
7th.
Absolutely not. Absolutely not true. The first time he spoke, it was this morning, and when he did, I went to Detective Kidd and told him what he said, and we had a discussion with Mr. Brown concerning that. And
He did tell him April the 7th.
asked
Man,
Mr.
my
Brown,
guy's
it's
staring at me. He
simply
told
the fact
Thomas
that
Wayne.
we never ever discussed his wavering, quote unquote, on this identification. I never had any information that he spoke to the investigator or to Ms. Kingred until this morning, and that is absolutely.
So all of this changes my lawsuit.
if I could briefly
I was
respond,
thinking-
Judge. Let me see where I should
Did you
begin.
catch it real good?
Okay.
Yeah, because he.
Okay,
The first
explain it
thing
then.
that
No, he just saying that he didn't talk to him until that morning.
We're saying that this is an ongoing thing about the identification. Kenneth Brown brought it to your attention on April the 7th and yesterday. He said he never talked to Kenneth Brown yesterday at all, but rather this morning, the day of trial.
Right.
We saying you didn't talk to Kenneth Brown and he has doubt on 2 different occasions and you never told us. So let's see one more time.
troubling is that
was capable of doing such an outrageous thing, then you could supply the motive. And if she were on trial, maybe it is something we would put in.
If she
I'm
was
not
on
aware
trial,
of the terms of that life
you can put it
insurance
in there?
policy.
I
I'm not
read the
aware
term.
of, who the beneficiaries are. I know that she was one of them, and I think his mother was the other one. And maybe they should equally suggest that his mother killed him. And maybe that's the kind of evidence we're going to hear.
So if he read it,
To call that
he
purposeful
knows
withholding of
everything.
exculpatory
You
evidence
know who the beneficiary are.
boggles
You-
my mind.
you
And
just
it
caught
puts
yourself in a
terms that
stupid
are
lie.
so accusatory and so
So
personal
Jim is on all of
outrageous.
this.
And I ask the court to
Jim's
make a
on all
finding
of
of fact that none of those things exist.
No,
and
this is
move
why
on
they're
to
saying my constitutional right to a fair trial was beyond violated.
Paragraph 8 of the written motion
It is-
indicates that
this
Mr.
is-
Brown came to you
this
as
is a-
early as April the 7th.
Absolutely not. Absolutely not true. The first time he spoke, it was this morning, and when he did, I went to Detective Kidd and told him what he said, and we had a discussion with Mr. Brown concerning that. And I'd be happy to bring it to ask Mr. Brown, because it's simply the fact that we have never, ever discussed his wavering, quote unquote, on this identification. I never had any information that he spoke to the investigator or to Ms. Kingred until this morning, and that is absolutely the fact.
if I could briefly respond.
Well,
Judge.
Keith, I gotta go. I gotta get Serena. Gotta go work in a minute. So you got all this stuff. Like I say, stay on guard.
I'm ready to get on this. I am.
Yeah.
He read, So
Yeah.
how many is it? This is 2.
The first
I
thing
want
that
to
I
bring back to the other one.
find troubling is that
What other?
Mr. Chauvin is
Kenneth Brown.
arguing that we attempted to inject
22?
heroin in Kenneth Brown's
Oh,
mouth.
Brown, yeah.
Papa got a brand
If I
new.
could give some background to the court, and my investigator is also
Papa.
on call. How this came up
That was his son?
was it
Man,
as
we
a
need-
re-interviewing of witnesses
12.
prior
What
to
is
the
it?
trial date.
1200?
Yeah, it's what he said.
We had heard
Bullets
from
is
another
big.
witness, Jim Tucker, that this had happened at the April